When a loved one dies, people may be searching for the will to understand what the deceased person's intentions were in terms of the distribution of property. And oftentimes the originally signed will is not able to be found, especially in today's day and age where perhaps the digital copy on a computer is identifiable but not the original will. And so the question for the family is, are we relegated to Ohio's default law in terms of how the property would be divided, or could we have this digital copy or other copy of the will admitted to the probate court and the deceased person's wishes honored using that copy? The answer is yes, and there's a process for doing that. It's called the admission of a lost, destroyed, or spoliated will. And so in a typical will situation where the original exists, you go to the court, and as long as on its face it meets the requirements for a valid will, it will be admitted to probate and property will be distributed pursuant to that will. In this instance where the original will is not available, you must demonstrate to the court by clear and convincing evidence that the testator had signed the will in accordance with all the normal provisions required to sign a will in the state of Ohio and what the contents of that will were. And so, as you can imagine, perhaps having the two witnesses that witnessed the will available and demonstrate to the court, yes, I was there that day, I was there when the deceased person signed it and it contained these provisions, may demonstrate to the court that the testator, the deceased person, did actually sign a will, and they will admit that copy as the will itself, and then the estate will be administered pursuant to the copy of the will, even though the original is not available.